I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Juror podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
Yes. And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, want some coffee?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, 13th jurors. Good morning. Good morning. I'm trying to get used to streaming on this setup again. Hello, friends. Hello. Big day today. We have a motions hearing, and I am really excited because we are going to be hearing, let me end this poll. End that. Move this. I got to get used to, see, by the time I get used to streaming in the condo, then I'm back in the house. Let's get it all set up. Okay, I think we're ready. So motions hearing today, there's going to be some big stuff talked about. So here's what's on the agenda for today. We're going to find out about the crash daddies, the ARCCA witnesses. They are trying to find a solution right now because #Hank wants to exclude the crash daddies if they are not able to give more discovery for him to look through. The problem with giving the discovery is they are hired by Department of Justice. So with the whole federal investigation and federal grand jury and all of that stuff has to stay kind of secretive. So they're very limited on, by the feds on what they can share. So Brennan said he put in a TUI request to get all the information from the ARCCA crash daddies, and if he doesn't feel like he has enough discovery or doesn't get everything he wants, then he is going to motion to exclude their testimony, which would be a tragedy for literally everybody, because who doesn't love the crash daddies? So we will hear that. We should also hear, which I'm very excited to hear because this is really juicy, the arguments over the whole debacle with the defense arranging with Brennan to have an expert fly out to Canton PD, because now all of a sudden there's all these videos. Where the heck were these videos? This is a big deal. If you haven't listened to the podcast episode yet, I broke all this down. So this is a huge deal. They just do what they want in Canton. It don't matter. So they had a defense expert fly out from Phoenix all the way out yonder to Canton, Massachusetts, went to Canton Police Department and was going to go try to get the original, like an original copy of the any digital files, anything, any video footage that's available. So they were going to get it directly from the like the system itself, right? So that way there's like metadata, they can tell, because at this point, like, look at the videos that we have, y'all. There's like an inverted Sallyport video, and then there's like the time stamps that are changing colors and directions. And then there's, missing footage, and they say that it's, that it's motion activated. There's literally motion when you're pulling a car. That's a whole car. That ain't even a little car. It ain't a clown car. It's not a golf cart. It ain't a bike or a scooter. It's a whole big ass car. It's a big car. That's like the definition of motion. Moving a huge SUV into the garage. If that ain't going to set off the motion detectors, what do you have it set at, sir? So they are obviously looking at all of these issues, and like this math ain't mathin'. And so they were going to go get all of the original files so that they can look and see what it was themselves with all the data and see, is this just the world's jankiest police surveillance system, or is there something else happening? Because this just don't seem right. So dude flies all the way out there because they arranged this, and they get there and they only have the video on there for 30 days. It's set to delete and overwrite it with something else after 30 days. Here's why this is a problem. They just got some of this footage given to them in October. The other footage that was given to them, some of it after trial had started, and then some of it right before trial. Now, I'm not the world's greatest mathematician, but I know that 30 days from January 29th of 2022 is, carry the 4, count. It's not October of 2024. So I don't, that should be a huge discovery violation. How do you have all of this video that is only supposed to stay for 30 days, but you didn't turn it over? Here's another problem. On this recent video, they have our buddy Higgins up in there on the phone with somebody at, what was it? I added it to the timeline. Anybody that has the Karen Reed trial Google sheet that I have that big timeline. I've already added it in there to the timeline. The time that they have him on the phone and the time that he was leaving. So who's he on the phone with? This changes things, because if the defense is saying, that he immediately went into gotta cover this up mode, which is what they've been saying, now they have video of him on the phone with somebody right after this happens. So it kind of changes things, because now it's like, look, this isn't a fishing expedition. This is, whatever. So that could be a very narrow Rule 17 request. Just, the records for just, midnight, until midnight on the 20, as it turned midnight on the 29th or whatever, until midnight the next day. That could be a very, very small scope that to me would be an easy thing to approve. It's not, but what do I know? It's just kind of crazy, right? It's kind of crazy. I think that I am losing faith more and more as this ridiculousness goes on. Then, so we'll hear the arguments on that. So it costs $12,000 to fly this dude out there. And so the defense is now like, bro, you told us, yeah, go ahead and send them and we'll, allow them access to this. And then we get there and they're like, I don't know what to do. I don't know. And then they don't have it on there. So Brennan filed a response saying that the defense, he doesn't think that they should have to pay the defense back because he didn't guarantee them it was on there. And they had said, please don't mess with it before we, if you know that it's set to overwrite after 30 days, why would you not say that? I think they absolutely should have to pay him back. Keep in mind, they did this kind of stuff, not to this extent, but Lucy, but they did this kind of stuff. Remember, they changed over different things last year, like the last minute would change the hearings and stuff like that. So it would end up being, you know, like costing the defense money to do all these things. I don't know. It's just, yeah, that Colleen lady acted like she didn't know they were coming. Like when defense said in the filing, like, we talked to her on the phone. There's no reason for her to be confused that they showed up. So I don't know. Yeah, in the pretrial last time, every single hearing was an outrage. Yeah. And if y'all listen to my podcast episode that I put out yesterday, I may have been a little snarky. Maybe. Potentially. I just am kind of annoyed with, you know. Babe! Hold on. Hold on. All right. Sorry. So sorry, I tried to mute that before. Ignore me. Yeah, okay, so it's not snarky, it's honesty and BS of what they are doing. It really is. Like, I don't like the way that Brennan is handling this, and I don't like the hypocrisy of it. I think hypocrisy is one of my biggest pet peeves, and it's running rampant in this trial. Like, you know, not only with the, yeah, my face is turning red. I know. Stop pointing it out. Y'all behave. It's turning this whole situation into a, like, it's hard to watch, you know, because I get so frustrated watching what they're doing. And it's not just the, you know, I thought Lally drove me crazy, but Brennan is, and this is my opinion, which I'm entitled to, and if you don't like it, you're entitled to yours as well. The way that I see it, it's like he's doing this in a very dirty way, and I don't like that. So it'll be interesting to see what they say today. It'll be interesting to see what is decided. You know, nothing will be decided from the bench. Nothing ever is. She'll take it under advisement and then issue her rulings. Also, yesterday was the day for all discovery was supposed to be due for the Commonwealth to have all of, I kept wanting to say state, but it's not the state, it's the Commonwealth of Massachusetts. So yesterday was the day for them to have all their discovery turned in. So we'll see if they met that. Mob lawyer was the perfect choice. He's behaving like a mob lawyer. You know, and I think I even said that in the latest episode of the podcast, that he is trying to prosecute this the way that a defense attorney, which he is a defense attorney. That's what he is. He's a defense attorney. He's brought in as a special prosecutor, but he's a defense attorney, and he's going about this as a defense attorney. The problem with that is a defense attorney will do different things because they are trying to, you know, put on a rigorous defense for their client. Sometimes you have to, you know, like look at whatever, you know, issues. Like I know a lot of times, like, you know, they're policing the police, and like you have to, like, you know, make sure that the investigations were done right and things like that. So I get that defense attorneys are looking at things that are more than just the evidence, because it's a much different position to be in. You're coming at the whole situation very different. And I get that. And so sometimes it ends up being like looking at like technicalities and ways to get things excluded and stuff like that. I get that. But the way that Hank is doing this, he is doing this as if he's a defense attorney, in the way that he's trying to prosecute her by keeping her from putting on a defense. And that's not, so, like, sometimes when defense attorneys will try to keep the prosecution from being able to present some kind of evidence that will work against their client, he's like doing the same thing, but from the prosecution side. And that's not how it works. You don't get to prevent somebody from putting on a defense. He's like, out of the 5 experts that testified for the defense, he is now like trying to exclude 4 of them from testifying, and I used the example yesterday in the podcast episode. I used the example of Dr. Dorothy Lewis in Letitia Stout trial. Remember Dr. Lewis? She has all kinds of, experience, and like she's, written books, and she's very well-respected doctor. She came out and said that she believed that after her interviews with Letitia, that Letitia had dissociative identity disorder or DID, multiple personalities, whatever. I don't agree. I knew from the jump that Letitia was crazy, but she's sane. She knew what she was doing. She doesn't have multiple personalities. I respect the doctor, and I'm glad that I got to hear the other opinion because it makes me feel stronger in my beliefs. Oh, she cray. Yes, no, zero. She cray. Let's not get that confused. She cray, but she's sane. She's legally sane. So I'm glad that I got to hear, because you don't want to decide on somebody going to spend, potentially the rest of their life in prison without being able to hear their side of things. That's not like that's. So I used that as an example yesterday. I'm really glad that I got to hear, even though I disagreed with her, I'm really glad that I got to hear Dr. Dorothy Lewis's testimony. And Lord help us, those videos. I was playing those for Chat Daddy. So I redid the entire Letitia series, and so we listened to it in the car. He listened to it on the way to the beach, and then I rode back with him here, and so we listened to the rest of it on the way back here. And he's so into it, so he was like, so I've got one more episode I have to do, but the first 6 I completely redid, and now I'm going to do the final episode that I haven't done yet. But it's funny because it's he's like, she's crazy. I was like, yeah, I know. Oh, I know. She cried, but she's sane. She's sane. So anyway, Dr. Dorothy Lewis was the first one on my mind because I've been having to re-listen to all those calls and all those interviews and all that stuff. So she was the first one on my mind. I am glad that I got to hear her give that side, but I am also like, it made me feel stronger in what I believe to hear the other side and know that I disagree with it. But not knowing the other side makes it a lot worse, So I don't know. I think that trying to prevent the defense from putting on a defense is dirty. And a lot of the stuff that he does is dirty, and it really just annoys me. So, oh my God, the hair curtain. When she did that. And then I had to show Chat Daddy some of the videos too, because I'm like, she has like these moments where her head is like flat on the desk and stuff. And then like when the calls are playing, like the calls that the FBI recorded, she's like, oh, this heifer cray, but she's legally sane. She's sane. Yes, you saw a kitty. That is Champ. Hi, Champ. Champ's a cutie. All right, let me get to some of this because we had some starred stuff. All right, Denise, welcome back. Welcome back. And C. Morales, member for 20 whole months. Hey everyone, so happy to be here. We are happy to have you here. Marilyn, hello Marilyn, we miss you. Love and miss you, Brandi. I love and miss you too, Marilyn. It is good to see you. 21 whole months. Mod extraordinaire, Dinah Do for 20, member for 20 whole months. OMG, 20 months already. How I love you all. I've missed you guys. 13 Juror. Yes. Yes. Tori the Seed Lady, member for 18 whole months. Great to see your face this morning. Good morning, family. Thank you for the love. Hello, Tori the Seed Lady. We love you, and you are in thoughts and prayers. I know cancer treatment sucks, but I promise you it gets better. I promise you. Chad Day knows the Thommy song, right? No, not yet. Actually, I have been introducing him to some of the old cases, though. I was telling him about Travis Rudolph, and it was funny because we were sitting there talking about it the other night, and we were watching the OJ documentary. If y'all have not seen that, you need to watch it. It's a 4-part series, and it's you need to watch that. You need to watch it. But we were watching that, and we kept pausing it to talk, and because, you know, we can't shut our mouths. And so somehow something in the OJ documentary triggered something about Travis Rudolph. Anyway, we're sitting there talking about it, whatever, and I was telling him about it and showing him some of the videos and stuff. And I was like, that one's a whole nother. I need to do some episodes on that, some documentary episodes or podcast episodes on that, because that one was, whoa. That one's still one of the ones that like just gets me. I have the interviews that I did with Mark the Shark and Mark Shiner and Heidi, because I did one interview with just Mark and then one interview with Mark and Heidi. So those are available on the podcast, like the whole interviews, the audio of those. But I haven't done any actual episodes on those. I need to. What? Why are you meowing? Hi. She was wearing earplugs made from toilet paper. I forgot how ridiculous she was until I had to go back and listen to all that stuff again. Has Chat Daddy seen the Hair Days? No, not yet. Not yet. We'll wait till our first anniversary to introduce him to the crazy side. Do I want another cat? No, we have a whole farm up in here. We have 3 dogs, 3 cats, and a turtle. And youngins. I mean, like, I guess our youngins aren't really youngins anymore, but the youngest one is 17. His daughter's 17, and obviously my kid is 21, but he has to see the Hair Days, yeah. That's exactly how I watched the OJ doc too. Yeah, there's so much to talk about, right? Because like I'm watching it and I'm like, you know, there's a lot of things that I didn't know. It's weird how you think that you know a case, you know, but then you hear stuff and you're like, whoa, like I didn't know that, or I don't remember that. There are very specific things I remember. You know, something that like bothered me that I had to stop and Google, like search the video to bring it up because I knew I wasn't crazy. I remember telling Chat Daddy when we first started to watch it, I was like, or when we decided to watch it, I was like, I remember I was in middle school when that verdict came out. And it was the first time that I remember people being so incredibly, like invested in a trial. And I remember we had those TVs, like the big, like box style TV, you know, and it was like, it was, they set on like this arm thing that came out of the wall in our classrooms. I was in middle school. And I remember every teacher in every class had it on because they had the trial that had been going or whatever. And then they had the day that the verdict was going to be announced, they had like there was no, like everybody was like, the teachers were like, F them kids, like we're paying attention to this. I remember it being such a big deal. And so then there's so much buzz about it that, and I remember where I was watching the, you know, Bronco chase and stuff, like, cause that was on TV. I remember watching that with my, you know, my brother and my parents. It was such a crazy thing. And so I was telling him, I was like, I remember when they announced the verdict and they, like, the juror who read it, like, stuttered on his name. She was like, Orenthal James Simpson or whatever. And I was like, and whatever it was about that, me, like, how old was I? Like 12-year-old me or whatever. 13-year-old me, whatever I was. I remember thinking, like, when she stuttered, I don't know why that stood out to me my whole entire life, but I remember hearing that and like being like get to it, and like that stutter thing stood out in my mind. So when they read that in the documentary, they edited that, and I was like, what the heck, y'all? Like, that's like that was like a part of my childhood that you just changed. It's the weirdest thing in the world, but I just remember that stuck with me. And yeah. Yes, we have a turtle. We have a Chinese box turtle named Bruce Leroy. He's adorable. Hi, Jen. Yeah, there was a lot of things I didn't know or forgot. I didn't know that they only deliberated for 4 hours. I didn't remember that, or I don't know if I ever knew that. I was a teacher that had to sneak away to my boss's office to watch OJ. Oh, all the teachers had it on when I was in school. It was funny. Wasn't that the first to use DNA? They had a lot of DNA. Like, they had like 50 samples of DNA, and that whole thing was huge. That whole thing was huge. That, like, there was stuff that came out in this documentary that I didn't know. I love that name. Yeah, Bruce Leroy. He's our Chinese box turtle. I've posted pictures of him before, of him like smiling and stuff. It's cute. He cute. Bev is on. It's not on mine. Hold on, let me pull it up on. It hasn't started on this one. Let me see if it started on another one. It's still showing that it's waiting on mine. Oh, now it just started. Okay. Do I need to turn the volume up? Maybe. Let me do it just in case. What are we waiting on? Oh, I'm ready for this one.
To save me time, does your expert in his affidavit say that this information was erased or that it wasn't there?
Wasn't there.
Okay.
It was erased by an operation of automation.
But do I bother reading your expert's affidavit again so it's not in there?
And I'll address what our concerns are in my oral statement.
All right. I'll hear you.
May I?
Yes.
The court started by asking what is it that the defense is asking for. Basically, we're asking to be treated equitably and fairly. This really is an issue of equity, an issue of fairness, and the court maintains this court maintains the inherent authority to issue sanctions when there is an injustice, and those sanctions can include something like cost-shifting sanctions. And there's a body of law that exists that deals with this exact thing, and that body of law includes the case of the Committee for Public Counsel Services versus the Attorney General. That's at 480 Mass 700. It's a 2018 case. The court may remember what was, I think, pretty widely known here in these parts, which was the Amherst scandal. Had a bunch of cases going back from 2010 all the way through.
I'm very familiar with the case.
All the way through 2018, and it culminated with Justice Gaziano discussing in his opinion, single justice opinion, exactly these types of things. And what Justice Gaziano said was, or held was, quote, the Attorney General does not dispute that the court has the authority pursuant to Rule 14, sub C, sub 1, to impose remedial monetary sanctions for a discovery violation. And he cites Commonwealth v. Firth, indicating that sanctions may be imposed under Rule 14 for failure to comply with discovery obligations, and sanctions should be tailored appropriately to cure any injustice resulting from a party's non-compliance with its discovery obligations. So the real question before the court today is, and really the only question before the court today is, has Ms. Reed suffered any prejudice based on blatant discovery and Brady violations by the Commonwealth? And the answer to that question is a resounding yes, she has. Your Honor, Ms. Reed, as the court knows, is on trial for her life, and she's been expending precious resources for some 3 years now defending herself against provably false allegations. And at the center of that storm of defense are these Sally Port videos. It should be pretty straightforward, really. I mean, it's just a series of videos at a particular location for a particular time. And that time is January 29th, 2022, from midnight until 11:59. It's a 24-hour period, 23 hours and 59 minutes. It should be pretty simple, but it has been anything but simple in this case. We've been asking for a full download of every single one of those cameras and all that footage from January 29th, 2022, from 12 a.m. to 11:59, but we've never gotten it.
When did you first seek it?
We asked for the preservation on February 2nd, 2022, when Mr. Yannetti said retain and maintain all physical evidence. We've been seeking these videos since well before the first trial. We didn't get them before the first trial.
Do you have a date? Do you have any chronology for me?
I don't. I can certainly provide those, but it's been...
I'd like that. I mean, that would be helpful.
I'll be happy to do that. It's in discovery request after discovery request after discovery request. Basically, there's also a catch-all. We've been asking for all physical evidence concerning video footage from Canton PD from well before the trial. We didn't specify which cameras because we didn't know which cameras had video footage. We didn't know how many cameras there were, but we didn't get anything from the Commonwealth. And I'll address that in particular in just a second. Mr. Lally didn't give it to us before a full download before the trial. The Commonwealth didn't provide it during trial. And today, as I stand here, we still don't have it. And interestingly, Mr. Brennan does make mention in his opposition that, quote, at no time has the defense ever made a formal preservation request. I found that interesting for two reasons, and I have two comments about that. First, as the court record reflects, on February 2nd, 2022, I just referred to it, Mr. Yannetti filed a preservation demand for, quote, all physical evidence to be maintained. That DVR, the footage on the DVR, is physical evidence that was required, not requested, but required to be maintained by the Commonwealth pursuant to that demand. But second, and this is probably more important, it wouldn't have mattered if we didn't ask for it to be maintained. It wouldn't have mattered if we didn't ask for it to be preserved. This was a self-executing duty by the Commonwealth. As Justice Gaziano stated in the same case, the Committee for Public Counsel, quote, a prosecutor's core duty is to administer justice fairly. To fulfill that duty, a prosecutor is required to turn over exculpatory evidence to a defendant without regard to its impact on the case. The failure to disclose evidence favorable to an accused that is material, either to guilt or to punishment, is a violation of due process. Litigation strategy plays no role in this process. Under our rules of professional conduct, a prosecutor is required to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate guilt of the accused or mitigate the offense. And he cites Massachusetts Rule of Professional Conduct 3.8 subsection D. The Commonwealth's Brady obligation is self-executing, Your Honor. It wouldn't have mattered one whit if we didn't ask for that footage, but it turns out that, in fact, Mr. Yannetti did ask that it be maintained. And the Commonwealth has still failed to preserve it. What we have gotten, it appears, are scraps and fragments of videos that the Commonwealth has decided on their own, and within their own time frame, to dole out to us over the course of months and years. And included in that scrap and fragment was a video that was missing 42 minutes. The court is well aware of this video. It was heavily litigated and heavily referenced at the first trial. That's the exact time frame, the missing portion is the exact time frame that the SUV was being pulled into the Sallyport. We got that video on April 4th, just days before the first trial. Keep in mind, it's a video from January 29th, 2022. Another one of those videos was the inverted video that has now seen some fame, that the Commonwealth tried to sell to the jury as a true and correct copy of a video within the Sallyport, and we got that one after the trial started, in the middle of trial. So why were we getting videos from January 29th, 2022, 2.5 years later? And why were some of those videos altered or manipulated and not in their proper format? We still don't have answers to those questions. And literally, while we're asking that question and while we're pondering that question, a couple of days ago, we're getting yet more videos, scraps, piecemeal. We got another Sallyport video just a few days ago, this one showing the Lexus backing into the Sallyport from some exterior camera. And that also is exculpatory evidence. Mr. Brennan writes in his opposition that the idea that the defense has been misled or was misled in its efforts to try to go secure that DVR footage is a distortion of the facts with, quote, no legal merit. Really? A distortion of the facts with no legal merit? Where's all this footage coming from, if not the DVR? It's the only place it was held. It's the only place it was captured. So of course we were misled by continually getting these piecemeal snippets of footage from the DVR, from the very source, had to have come from there, coupled with the Commonwealth saying, and Mr. Brennan saying, yeah, come on out, you can have your expert come out, meet us at Canton, we'll provide the DVR, you can have him look at it, he can bring his equipment, download whatever you want from that 24-hour period. So what were we to believe? That it was on the DVR. It had to be. How else were we getting these piecemeal videos? And they've had that DVR for 3 years. They knew exactly what was and what was not on that DVR. They had to have. This has been the center of a storm that surrounded this case from the jump. And to claim otherwise, it's just patently absurd. So Mr. Brennan also wrote in his opposition that Mr. Jackson said, don't touch the DVR, don't mess with it. So I informed Chief Rafferty, tell your staff, don't touch it, don't mess with it, almost suggesting, intimating that it's my fault that we didn't know what was on the DVR. That's absurd also. How am I supposed to know what is or isn't on the Commonwealth's DVR? What I actually said, that was a sort of a liberal interpretation of the facts. What I actually said was, Mr. Brennan, do me a favor, if we're going to come out there, just don't have anybody download it in advance. Let's do it all together when we're all in the same place. That's what I said, and he accommodated that. He said, sure, we'll agree to that. So based on this history of getting these small clips from January 29th, we knew there had to be more footage. So when Mr. Brennan came on board, we made the request to him as well as the requests that we had made to his predecessors. We want all the footage for that 24-hour period. And lo and behold, we started getting more clips, more snippets, more piecemeal bits and bytes from that DVR. And one of them was a clip of Brian Higgins standing out in front of Canton Police Department in the parking lot in the freezing cold at 1:35 in the morning on January 29th on his cell phone. To punctuate the importance of that video footage, recall that this issue was raised at trial. We talked extensively. When I say we, both the Commonwealth and the defense, me in particular, spoke with Mr. Higgins about this issue. It was raised at trial, and Brian Higgins never once, not once, on direct examination or on cross-examination, admitted to having made a phone call in the middle of the night on January 29th. And yet now, after the trial, we get a video of him doing exactly that. And that also proves that he lied in front of a federal jury, in front of a federal grand jury, when he testified that he didn't have or make any phone calls in the middle of the night. That is called exculpatory evidence, and that's Brady evidence, and it was withheld in its entirety during the first trial and for the last 3 years. And it's against that, the reason I bring that up, Your Honor, it's against that backdrop that we then say to Mr. Brennan, kindly give us the footage. I don't want this piecemeal thing to keep going on. Just give us the raw footage. We'll send an expert. So the plan was put in place, and experts were retained, and flights were booked, and hotels were reserved, and transportation was arranged, and all at Miss Reed's expense. She's writing the check for all of this. And our expert flies out to Canton, walks into the room, and within 10 minutes, they open up the front plate of the DVR, and lo and behold, the Commonwealth says and agrees, oh goodness, there is no footage. It was overwritten within 30 days. What? How could that possibly be? So the expert calls me. Mr. Jackson, what do you want to do? And I said, I don't know. I'm not a tech. That's your job. I don't know what to do. If it's overwritten within 30 days, I don't know. Maybe there's a log. Let's find out who has access, whose digital fingerprints were on that DVR, who downloaded the footage, when it was downloaded. What about these clips that we have? I'm very confused. So the expert goes back and says to the technician for the Commonwealth, Colleen Crawford, well, let's at least download the log. At least we can have access to that, and we can start unraveling what's going on here. Oh, sorry, that's been overwritten as well. There is no log. You get no footage, you get no log. This was a complete and utter waste of time. According to the Commonwealth, that system, as I said, overwrites every 30 days. So by February 28th, I counted them, by February 28th, 2022, every single frame of that footage should be gone. So how did we get the inverted video in April of 2024? How did we get the video clips of Brian Higgins in October of 2024? How is that possible? The only explanation, Your Honor, is that the Commonwealth downloaded the entire system within the first 30 days. Otherwise, it's gone, admittedly. And all of that has been withheld from us for 3 years. Then to add salt to that wound, the Commonwealth allows us to go on this wild goose chase, spend $12,000 some odd of Miss Reed's money, and fly an expert out to Canton for absolutely no reason, zero. The 30-day overwrite protocol is something that their technician absolutely would have and should have and did know before we ever set foot in Canton. She was well aware of exactly why we were going out there. We were going out there to download footage from 3 years earlier. She knew it, we knew it, Mr. Brennan knew it, everybody knew it. But within 10 minutes of walking in the door, it was revealed that there, in fact, was no footage. And that's a fact that the Commonwealth had to have been aware of for the last 3 years. Yet Karen Reed is the one having to foot the bill for what turned out to be just a snipe hunt. It's not fair, and the Commonwealth should reimburse her for this fool's errand that was not of our making, of her making. The Commonwealth has since told us, Mr. Brennan told us, that remarkably he went to Canton PD, and this is in his opposition paperwork and his declaration, and he spoke with some officer. And that officer told him that he, the officer, personally made a copy of the entire January 29th video footage and placed that copy in some sort of an iCloud account. Not on the DVR system, not in the official data bank in which it's supposed to be stored, but on some iCloud account. And we're finding out about this in 2025. It's outrageous. What it is this entire situation surrounding this DVR and the Commonwealth's maintenance of that DVR and the footage on it is a complete dumpster fire, and Ms. Reed has to pay for the fire extinguisher. And that's not fair. The High Court and the Committee for Public Counsel, the same case that I referenced a little bit earlier, and the court will know this because this was sort of the big takeaway from that case, is Justice Gaziano fashioned a cost-shifting remedy against the Commonwealth and for the defense. And that included the entire cost of investigating and locating and contacting nearly, I think it was 10,000 defendants. It was an enormous amount of money and an enormous undertaking. And the Commonwealth had to foot that entire bill. And the reason they had to foot the entire bill is because the Supreme Court decided that it was prosecutorial discovery violations and cost-shifting remedies were in order. We're asking absolutely no more than that from this court. Fairness dictates that Ms. Reed be reimbursed. And I'll submit, Your Honor.
All right, thank you very much. Mr. Brennan?
I did not know about the iCloud thing.
It's notable that the defense purposely conflates two very separate issues. If you had a chance to read their motion, they suggest that they should receive costs because they hired an expert, came to Canton, and didn't receive the information they wanted. Yet today in the argument, they try to give you a historical complaint about the production of videos in this case. That is a separate issue. That's a Rule 14 issue, but that is not the motion before the court. The reason I suggest they conflate the issues is because they know their merit for costs. I mean, their motion for costs has no merit whatsoever. And so what they're trying to do is incite facts, invoke this injustice they've created so that the court looks at the motion that they actually filed and gets it distorted. It is disappointing to stand before a court and file an affidavit as an attorney and have someone else have a cross affidavit. Frankly, in my career, when that has happened on rare occasions, I find that embarrassing. There is very skilled and able attorneys in this courtroom, and to work out discovery matters and agreements is something that attorneys always should do. And that is what I've tried to do in this case. I have tried to give the defense the best opportunity I can to get whatever information they want, whether it is required or not required. Yet, I'm standing here today, and I have to now share with you my conversations with the defense. I have to share with the court my position, which is contrary to the defense, because they have lodged a motion asking for money that they are not entitled to. If I stand back and do nothing and remain the dignity of the court, then what happens is there are claims that just float out in nowhere.
This means he got dignity.
That becomes the truth. So now I must stand before you and I must tell you what happened. When I entered this case in September and I began to look at discovery, I saw a video produced in August from the Canton Police Department, and we immediately turned it over to the defense. I began a study of the case and tried to articulate and account for all evidence and make sure the defense obtained everything that they were entitled to and more. The defense asked me to try to account for the video because they believed it had been an issue in this case. I looked through the docket. There was no motion to preserve videotape. I read the pleadings. Attorney Yannetti was meticulous in his motions to preserve. It was admirable. It was meticulous, the work he did. There was no motion to preserve, and that has some import. It doesn't relieve the government of their obligation to provide Rule 14 discovery or exculpatory evidence or Brady evidence. It doesn't relieve the Commonwealth of their obligations to be dutiful, but it is difference in kind. Because the defense, if they want something that is not obvious, they put the Commonwealth on notice. Having practiced for almost 3 decades, you file motions to preserve within 24 hours, 48 hours, or 30 days. And so when Mr. Jackson called me, Attorney Jackson called me, and he said he wanted to come out and bring an expert to look at the NVR or DVR of the Canton Police Department, I had never seen that in 30 years. It's not part of our obligations. He's not entitled to come into the Canton Police Department with his own experts and download his request. But in the spirit of transparency and an effort to help the defense so there will be a fair trial and they can obtain all the discovery, understanding the history of this case, seeing that there was an August videotape post-trial, I wanted to do what I could to accommodate them. So without any hesitation, despite that there was no court order, no motion to preserve, I invited him to come to the Canton Police Department. I called the chief of police. I asked the chief of police, although this was unique and novel, unprecedented, could the defense come and access their material? Typically, the Commonwealth will download it and provide them a copy. She had no hesitation. So I called Attorney Jackson back, and I said that we would allow it. Attorney Jackson expressed concern, understandably, being a defense attorney, that almost 3 years later, the video may not be on the NVR. I had the same concern. I want all of the evidence. I'm not looking for evidence that's good for the Commonwealth or helpful for my case. I want all of the evidence. And so after he expressed the concern, I made clear I had no idea what, if anything, was on the NVR. We could go and look at it, but Mr. Attorney Jackson didn't want that. He wanted his expert to be the person to open the NVR. And
I don't blame
his position,
him.
providing a professional courtesy, I agreed. I didn't mislead him. I didn't think there would be video. I had no idea. So Mr. Jackson, Attorney Jackson, pardon me, sent out his expert. And by the way, the expert that came was not the expert they designated. I got a call because we were in court on a hearing that they had sent a different expert they hadn't noticed. And my response was, it doesn't matter. Whoever they send, let them look at it. And so when they did, not surprisingly, the information had been overwritten. Now, while there was a 30-day override on that machine, I believe the defense expert knows that there was a backup hard drive which kept materials longer than that 30 days. I do know that there was materials on that DVR, NVR, back in July of 2024, and I know that from a report that was generated by the Commonwealth and given to the defense, so they should know that as well. That may be one reason why they wanted to come out.
What backup hard drive?
I extended the courtesy as much as I could, made no promises. I was clear, I was very uncertain about what would be on there since I never looked at it. After I learned there was no information on the NVR, I took the initiative and went to the police department. I viewed the police department, the cameras, I spoke to personnel, and I spoke to the retired individual who then was responsible for providing video upon request. And when I spoke to him, he told me in conversation that he would routinely store a copy on a file he noted as a detective file or on his hard drive. That was news to me. I thought that was helpful, so I notified the defense about my conversation. I was not trying to lure them back to Canton or have them spend money. I was trying to, as I always do, be as transparent as I could and as helpful as I could. Now, what I simply should have done and could have done is I could have gone to that detective file and downloaded the video and given a copy to the defense. That's my obligation, no more. But I didn't. I extended the courtesy that if they wanted to come and look at that file before we opened it, so it could be beyond reproach, they were invited to do that. I wasn't encouraging or luring them. I was inviting them. Because they had already been part of the process, I thought it would be disingenuous not to let them participate. And what they told me is to wait. So now that information, whatever it is, I don't know because I haven't seen it. And I've asked the detective or the retired detective not to access it. It is sitting in that file, supposedly. So at this point, it's the Commonwealth's position that we are going to go and download that information and give a copy to the defense. The defense waited almost 3 years. The defense was very clear about my uncertainty would be on that tape. And now they stand before the court and they try to parlay this into some type of injustice for their cause. The case they cite, Commonwealth versus Frith, the district court was overruled in assessing costs because there was no egregious violation. This is not a Brady case. This is not a setup. This is the government providing information as the case progresses and evolves and changes and retools. So what we have now is information, supposedly, on a database that we are going to get and give to the defense. You should deny their motion. Nobody was misled in this case. They've taken a professional courtesy and an effort to help, and they've distorted it into some type of injustice. The Commonwealth's not going to be distracted from the cause in this case, which is a trial on April 1st. The court should not be distracted from the cause in this case. If they have a separate motion about Rule 14 violations, or motion dismissed for misconduct, that's a separate motion. That's not the motion before the court today. The motion before the court today is to attempt to recover costs for something they chose to do and that I accommodated. It should be rejected. Thank you.
Okay. Any quick response, Mr. Jackson?
Very briefly, with the court's permission.
Sure.
By the way, it is a Brady case. There's no question that the data on those videos are Brady. They're exculpatory. That's where we start. So Mr. Brennan can say all day long, that's not a Brady case. Don't worry about it. Let's just sweep this under the carpet like we've done everything else. There's nothing to see here. That's not true. It's a Brady
Look the other
case
way.
The information that we have now received from that DVR, that NVR system, is exculpatory to Ms. Reed. That's why I cited
Brian Higgins' part?
That's why I cited the Brian Higgins part. Correct. And I suspect there's a lot more on there as well. The inverted video part is also Brady, which we got in the middle of trial. Mr. Brennan says, basically, his argument is, deny the motion because they took a courtesy. I'm trying to be courteous. And he's a gentleman. This is not personal to Mr. Brennan. He seems to, the tone of his responses was, well, this is personal between Mr. Jackson and Mr. Brennan. It's not personal at all. This is about the defense and the Commonwealth. It's about Ms. Reed and the Commonwealth. But let's not conflate a courtesy with an obligation. The Commonwealth has an obligation. I don't care that Mr. Brennan wasn't on the case previously for the last 2.5, 3 years. It doesn't matter to me. This is not personal to him. I appreciate the fact that when he came onto the case, he immediately found in August, he found a video that had never been turned over. I can't fault him for that. He turned it over when he found it, apparently. What I can fault is the Commonwealth. Mr. Brennan was brought onto this case not to represent Mr. Brennan, but to represent the Commonwealth. And all the foibles, all the warts and blemishes that preceded him, unfortunately, are now his responsibility as lead counsel for the Commonwealth. He indicates that when he found out that we wanted to come look at the DVR, and we had absolutely no right to look at that DVR, this was just a courtesy, etc. Well, that might be true if we hadn't made the request, because we had been getting piecemeal videos from the DVR system that it supposedly was overwritten.
So the oral request by phone call you're talking about?
The latest one, right. So my request to come out and have an expert come out and see it. That's not just a courtesy. That's just good lawyering on his part and mine. You want to keep your hands clean, let's do it the transparent way. Have everybody come, bring their experts, whoever they might be, and let's download this stuff together. So there's no funny business, and everybody can wipe their hands and say, I didn't have anything to do with it except downloading the material, and whatever that material is, it is. That's just good lawyering. It's not a courtesy. He was doing that to protect his own and the Commonwealth's interests, and it was quite smart until he realized, because he didn't have any way of knowing it any more than I did, that there was no footage. It had been overwritten. Perhaps, certainly the defense was deceived. Perhaps Mr. Brennan was deceived as well. He indicates that he contacted Chief Rafferty, and she said, with no hesitation, yeah, bring him on out here. I wonder if that lack of hesitation had anything to do with the fact that the chief knew that there was no data on the DVR. You can come look all you want to. The bucket's empty. I have no idea about this iCloud account or who owns the iCloud account, why this data on January 29th was moved from the DVR to the iCloud account. Mr. Brennan did say, do you want to have your expert come back out and watch as we download the iCloud account? And I said, let's defer that because this is literally, these are the contours of motion that's going to be before the court. And I still want to defer it, because what I didn't want to do is pay another $12,000 or $15,000 for a second bite at this apple just to find out that iCloud account is somehow compromised as well.
Can you have someone record it? Can you have somebody that it won't cost you $12,000 if you want to come out and just have someone record it as it's being done?
Sure, I didn't mean to interrupt the court. Yes, I can certainly make accommodations other than flying an expert out and having somebody do it in person. That may be an option that we exercise. I may talk to Mr. Brennan about that, because I still want to have some transparency on that process. But what I don't want is to throw good money after bad at this issue when she's already spent $12,000, $12,200 and something for absolutely nothing. This is not a matter of courtesy. This is a matter of obligation. This was a matter of Brady. It's no different. And by the way, the case that Mr. Brennan cites, he indicated that I cited that case. I didn't cite that case. Justice Gaziano cited that case in his opinion in the committee case. And the ultimate opinion of that court was, when there is a discovery violation, when there is a Brady violation, and there is no question that that's what's before this court, blatant discovery and Brady violations. The Commonwealth doesn't, the court may remember, by the way, on the witness stand when these videos were coming in piecemeal, especially the inverted video, 2 or 3 witnesses all went like this. I wasn't the one who told it. I wasn't the one that downloaded it. I wasn't the one that downloaded it. I don't know where it came from. It just ended up on my desk on a flash drive. I don't know where it came from. Everybody was pointing fingers at everybody else. Nobody could establish a single chain of custody for those videos, and we still don't have it. So Chief Rafferty's statement, yeah, come on out, no hesitation whatsoever. They can come look at it. I suspect it's because she knew it wasn't there. This was we were led in a circular runaround, and it was ultimately at her cost, and that's what.
So didn't the two of you, when you talk about good lawyering, didn't both of you agree that it was highly unlikely it would still be there? Or are you saying that part's not true? Mr. Brennan told me that.
I said, I'm concerned if we don't get out there fast. I don't know what the override protocol might be. So yes, I was concerned, but who cares? Well, that's no legal moment. What I thought and what Mr. Brennan and I discussed 3 years after the fact, when the Commonwealth has a self-executing obligation to provide that information to us because it's Brady. They also had an obligation pursuant to Mr. Yannetti's demand, not request, but demand to maintain that information.
So where is that demand? Is that in the file? Where is that demand?
February 2nd. I don't know what the docket number is. It was filed on February 2nd after arraignment.
Here?
Wherever
Stoughton. Stoughton.
It was in the Stoughton District Court.
Okay.
But it's part of the case file. And it stays with the Commonwealth, and that obligation stays with the Commonwealth. But I would propose to the court that even if the court's concern is, well, when was that filed, and did Mr. Brennan actually...
I haven't seen it.
April
I know
1st.
It's not part of our file, and you're talking about it as if it were here.
Your Honor, I can't say with certainty, but I believe that it may have been submitted as an exhibit to a previous motion, probably early on in this case.
Okay, I just wanted our record to be clear.
Of
You're
course.
talking about Mr. Yannetti filed this. You did not file it in this court.
I may have filed it as an exhibit.
Attachment, but it was never
not-
any...
Right. There was, I don't mean to cut off the court, Judge.
It was never brought before me or a judge who had this case before me to be heard.
So there was early on, and so many motions have been filed in this
Right.
case, but early on I did bring a motion, I believe before Your Honor, asking that all of the Stoughton District Court motions that I had filed at arraignment and thereafter be ratified by this court. That is in our record.
So I need you to find that.
Happy to do it.
And tell us when it was filed, the act. I need to see that.
By the end of the day today, you will have whatever submissions we provided, and if it's not part of an exhibit, you will have that motion.
All right. Go ahead,
Just
Mr. Chair.
to answer that one question that I can't answer because I've seen the filing. It was filed February 2nd, 2022, court stamp. My point is, even if that weren't the case, and it is the case, The obligation is self-executing. That's what Justice Graziano was talking about when he talks about in the committee case, the self-executing duty that a prosecution has or a prosecutor has to maintain and preserve exculpatory information and provide that information to the defense. They didn't do that, and they led us to believe every single sign and signal, irrespective of what Mr. Brennan did or didn't actually personally know. The Commonwealth's conduct in this case, from the beginning of the investigation to now, suggested that that information existed, the DVR existed, sorry, the video footage on the DVR existed, and we were going out there to download. We shouldn't have had to jump through this hoop and go on this wild goose chase at Ms. Reed's expense. It is not, I think we can all in this courtroom agree, none of this is our fault. We didn't do any of this. It's all on the Commonwealth's shoulders. It's all their responsibility. They should have to pay for what happened when we went out there for absolutely no good reason. I'll send that.
All right. Mr. Brennan, I have just a couple of questions.
Yeah.
So you don't know for certain whether this information was in fact downloaded onto the hard drive, but you suspect it is based on your conversation with the named gentleman in your affidavit?
So there's two different systems. One's called the DVR, NVR. That's the actual system that keeps all the footage that's recorded.
That
has been searched.
Commonly is overridden every 30 days.
Like has been overwritten.
Statewide police departments.
Yes, Your Honor. And that has been overwritten.
Okay.
And there is no information on that.
Okay.
When I spoke to the retired sergeant detective who had downloaded video, he said as a habit, he would routinely, when he would make a video copy from the DVR, he would place it in a separate file. I can't say that it's exhaustive. I can't say that it captures all of the video. It's when he would make a copy, and it seems in this case there were select copies made. It doesn't seem that there was ever a time when somebody just copied the entire event. Now, the issue of whether there was a request for it and the obligation of the Commonwealth, I think, is a separate issue. What exists on his hard drive in the detective file, I don't know. But what he has told me is he would routinely make copies of what he would provide to the court and the Commonwealth, or the Commonwealth and the defense, and he would put on that separate file. I don't expect, and I'm only guessing, that it's going to be an exhaustive copy of the entire night of January 29, 2022. I don't expect that. I expect it will be a copy of whatever it is that he has provided in this case. And so I think before it just lingers there forever, it should be copied and it should be provided to the defense.
All right. So I do want you and Mr. Jackson to talk about whether within the next week you do have somebody video it, or at your expense you send somebody out at it, but let's get moving with that. I know you said you'd make a download a copy and send it. Are you satisfied with that, Mr. Jackson, or do you want to have someone there while that occurs?
I at least want to noodle on that for a second, but I'll talk to Mr. Brennan about it.
All right. I'd like it done within the week. The person has to be there within next week, or the Commonwealth will download it. We've got to get this case moving, and you want it, so it's got to be provided.
The stall isn't my fault. Yes, we want it. That's why we asked for it in the first place.
So let's try and work it out before you leave here today, okay?
Sure.
Your Honor, I'm happy to defer the defendant's request. I'm prepared to do it now. If they want me to wait, they want to have somebody there, I'm receptive. But we're ready to do it now.
All right, so I'm telling you to please wait, work it out, but no later than next week.
I understand.
All right, thank you. Did you want to be heard further? In
Briefly,
response?
Your Honor, although I've come into this case late, I am the Commonwealth, and I assume all responsibilities of the government's case in the history of it. This motion is not about a Rule 14 complaint or a violation. If the defense has a motion for sanctions or to dismiss, or whatever the remedy is, because they think they've been agreed, that would be a different motion. This motion is they're trying to get the court, or asking the court to impose costs because they had their expert come out at their request, and they were very clear about the risk associated with that. This motion should be denied. If there's a separate motion, we'll deal with that when it's filed. If I had known that the defense was going to argue something entirely different, and that is
Oh,
failure
Lord.
to deserve, I would have made a copy of all Mr. Yannetti's motions and requests, and I would have provided them as an exhibit. But I did not do that because that was not the scope of this motion. This motion should be denied.
All right, thank you very much. Taking this under advisement. And do not wait for a decision from me on this about whether or not you send somebody out to get
won't.
that video.
We'll get started on that immediately.
All right. All right.
I'm not a fan.
So let's move on to the Commonwealth's motion for clarification
Oh
regarding
my
the
gosh,
search warrant.
y'all,
Or the
hold on. Did y'all see that? Turtle Boy has Grant up on his computer.
For clarification regarding the search warrant. Please.
In reviewing the discovery in this case, I learned that there was a search warrant for Miss Reed's phone. That search warrant entitled the Commonwealth to search for data that's outlined in what's known as Addendum or Catch's Addendum A. Learning the history of this case, I further learned that because there was an assertion of privileged communications, there was an agreement that the Attorney General's office would look through the data on the communications, and they would identify any attorney-client privilege information, extract it, and then provide the information back to the government and the defense. I am not sure of the accuracy, but I learned or read that the defense was given an entire data copy, forensic download of Ms. Reed's phone years ago. When I looked through the discovery, it surprised me that the Commonwealth did not receive the forensic data. It received a report, and when we reviewed the reports, it had references to navigation information and Google searches, but did not have any of the forensic download. And so clearly, the Commonwealth has a warrant, is entitled not only to the PDF extraction, they're entitled to the full force of that proof, which is the data. I spoke to my experts, and they advised that they believed that the data would have more information than simply a PDF. And so when I learned this, I wanted to both scrupulously protect the defendant's rights, but I also wanted the data for our review. And so I limited my request for the data to navigation information in the Google searches. Although I do not believe it was required pursuant to the communication protocol, I asked the Attorney General's office to engage in that protocol anyways, just out of abundance of caution and respect for the defense. I contacted the defense. The defense offered their objection. I think it has no legal merit whatsoever. They don't have standing at this point, but I noted their objection. I believe, without certainty, that the Attorney General's office has gone through that review to make sure there are no communications. However, they expressed some reluctance to provide the information because of the existence of the communication protocol, and they did not believe there was enough clarity that there was a distinction between navigation information. I do not see that navigation information, Google information, or the other data that I want is covered by the protocol. I believe that protocol has at least partially already been followed anyways. Time is of the essence. This case is on for April 1st. There is what I believe to be relevant material, important information, including Google information and navigation information that we are entitled to. I don't want delay. So I filed this notice so that the court could give direction, either assuring the Attorney General's office that they could provide the information, or if there is going to be a protocol, which I discourage, that it's expedited. If there is something the defense wants to look at prior to me receiving it, it should be on a very, very narrow time frame. I don't think they have a right or entitlement to review anything I get. I think the Commonwealth is entitled pursuant to the search warrant. If they have a remedy, it's after we've already reviewed it, not before. And so I'm doing this to facilitate things because I'm mindful of the April 1st trial, and we will pursue this information and use it if relevant.
Okay. Is there an opposition? I don't have anything in writing.
Your Honor, not really. The only thing that we expressed to Mr. Brennan was, and maybe I misunderstood his first, there was a communication that we had on the phone. I thought that he was seeking something far broader than the search warrant. It sounds like he's staying within the parameters.
It sounds squarely within the search warrant.
So that doesn't bother me. I want to make sure that whatever information he gets is squarely, as the court just said, squarely within those parameters. On January 28th at 9:30 p.m. until January 29th at 5:30 p.m. And otherwise, I don't disagree that pursuant to the search warrant, he can You can get I'm calling it raw data, but I think we all know what we're talking about. Not the PDF, but the underlying data.
All right, it's squarely within the search warrant.
Right.
I do feel Mr. Brennan did not have to come to me or even you with it, but I do appreciate that you did so. So yes, so the AG's office knows that you are entitled to that information. You may have it immediately.
Thank you.
Okay. All right. So the motion regarding, just want to get, Commonwealth's motion for reciprocal discovery pertaining to employees of ARCCA. And then if you go one step further than that, are we going one step further than that with the second motion today? Or do council want to come to sidebar and tell me any information you have? Or how do you want to do this?
Whatever the court's most comfortable with. An open court or sidebar.
I'd prefer to find out what's going on over in federal court at sidebar first.
No, that's rude. We want to hear. So rude. So rude. Did she just roll from the bench? Yeah, well, kind of. I mean, that one doesn't really have, it's not really something that she has to rule on because it's kind of between Brennan and the Attorney General's office, but, which is kind of, you know, probably the only reason she was like, yeah, sure. Doesn't have anything to do with me anyway. But it's a very easy request because what he's asking for is within the limits of the search warrant, so it's not anything that's like, you know, groundbreaking stuff. Of course she wants a sidebar. I can hear talking, but sidebar. It's all a big mess. Yeah, it wasn't something that even really needed to be heard. I think it was more for show. Tosh gifted a membership. Thank you, thank you, thank you. Mildred, 1 whole year. 1 whole year. I don't think Auntie Bev is going to budge on giving a Brady violation. Yeah. This judge actually did rule from the bench yesterday by giving her verdict in Penny McGee bench trial immediately after closing statements. Verdict not guilty. I heard that, and I was like, what? Which is interesting because that's not at all how she does things here. At all. I didn't get to watch it. Oh, I heard that there was the verdict in the kid too. I haven't got to watch any of these, y'all. I've been working. So I heard that the verdict with the kid was like a big deal, and then I saw RA's tweet about the jury in the case that he was streaming. Like, there's just been so much crazy stuff going on, and I've missed it all. RA face is always amazing. I love me some RA. Love me some RA. So I'm just seeing this. Somebody just sent me something. I guess one of my favorite trolls on Twitter had said a bunch of stuff about me and then had to retract it because anyway, that's funny stuff. I don't look at any of that mess. Miserable people try to make other people miserable too. The kid got away with unaliving his father 18 months earlier. How, like, I don't know. See, I don't know the details of it. No, Ashley, but it was one from that group. It was Dysfunction Junction over in the Collin trial. Really? I missed the whole thing. The state couldn't prove either case. They presented more against his mother than him. Interesting. Interesting. I like Dysfunction Junction. Did you think, so what are y'all, because I didn't watch any of it, y'all think that he should have been convicted? It's taking so long because they still have a lot of stuff that they had to get done, and both sides asked to have it extended. They have the testing that was done for the Lexus, and obviously they still have discovery like that they're not getting, so everything's taking longer. Me too. Hey, Wild Child. I can try it on this computer. I still can't get into it on the app in sorry, my kid. A drunk driver ran over a golf cart in Panama City Beach, and there's a 17-year-old girl who's, I believe she's still in the hospital, and the guy tried to run. They ended up getting him. They arrested him, but they gave him a bond, $25,000, which is, so a lot of people are mad. My kid's texting me about it right now. This is why I love my kid. He's texting me about this right now, and he said, I just read the mama's post. It's thick how people are in her comments like, well, how old was she? Did she have a permit? Is she a legal driver? He said, it doesn't effing matter. He ran over the golf cart drunk and tried to run. Love my kid. Got a head on his shoulders. It's me. forgot. When is your cake? I told him he should, because he's very entertaining too. So I told him he should have his own. But I'm also scared of that because I have so many like vicious trolls that I don't want him to get messed with because of people being douchebags to me over this case. But I love that he's getting into some of this true crime stuff now. Like, you know, he'll call me and text me and... Yeah, that was the one in South Carolina, right? Hello. People, see, I didn't watch this one, but people feel very strongly about this one. See, there's, you know, where I live, there's two main roads that go like along the beach. And so people ride golf carts up and down there all the time. They're not legal on like the back roads, like, not back roads is the wrong word. Like the main roads that are like back past the beach. They're not like on like the, it's a road, it's called Hutchinson Road, but it's like, it's 2 lanes of traffic here and then like a grassy thing and then 2 lanes of traffic here. And then there's Back Beach Road. Like they're not allowed on those roads. Those are much bigger, but they're allowed on the smaller roads. Which is fine until people get drunk and start acting like idiots. Nikki, hello! Happy 21 months.
All right, so I will hear you, Mr. Brennan, on your motion for reciprocal discovery.
Ah.
Your Honor, we're expecting to file a certificate of compliance this morning. We've provided voluminous discovery to the defense, and it is now incumbent upon the defense to reciprocate pursuant to the rules. I filed a motion to reciprocate. Also, there is a specific motion regarding expert witnesses relative to so-called ARCCA experts.
So-called ARCCA.
Those requests are consistent with information that we routinely provide pursuant to Rule 14, and we are asking that the defense comply if they expect to call these witnesses at trial.
And you've asked for, you have specific requests for the discovery, right?
I do.
All right. Mr. Jackson.
Thank you, Your Honor. I appreciate the opportunity to be heard on that. I appreciate Mr. Brennan's indication that he intends to file the certificate of compliance today. We know what our obligations are under Rule 14, and we intend to comply.
Okay. All right, so the motion is allowed. And Mr. Jackson, you had a scheduling concern?
I do. Concerning we received notice of discovery number 58 last night. It probably, I'm guessing it contains between a dozen, maybe 15 categories of new information that we're getting within that notice of discovery. They're substantial, including multiple experts, some individuals that we've never seen anything from. I believe that upon review and analysis, some or all of that will be relevant to our motion to dismiss, which I think is going to be pretty full-throated. The court indicated that it wanted us to file our motion to dismiss, I think, by the 11th, which is in 6 days from now. I don't think that's a reasonable possibility. We simply cannot get it done that quickly. I would ask the court, urge the court to allow us until sometime the beginning of March. We've got several dates on calendar. I don't have them committed to memory, but we'll be back at the beginning of March. That motion to dismiss, I think, if we have the time to do it and get it filed by the beginning of March, it's not going to take an enormous amount of court time. The time that's going to be taken is our preparation of the motion. But actually arguing it and ultimately the court either taking it under advisement or deciding on it, I don't think is going to be that burdensome. Although it's going to be a very, very full-throated motion.
All right, so you first raised the issue, I believe, in a footnote in one of your other motions that was filed, I don't know, January 21st or earlier, that this motion to dismiss is coming. You had a motion to dismiss it, the last trial, the same thing, forecasted, and then it's coming, it's coming. I need that motion in order to get it heard before then. Let me hear what the Commonwealth has to say.
Oh, jeez.
What's the extent of the information that you provided today or yesterday?
In the most recent discovery,
Yes.
it was voluminous.
Okay.
We provided a number of expert witnesses, entire files of expert witnesses. We've been providing discovery in an ongoing manner rather than wait until the end. When I've retained an expert, we've notified the defense. When we have reports, we've notified the defense and provided them almost immediately. But there is quite a bit of information that we put together regarding expert reports and data information, accident reconstruction, phone investigations. So we sent it by link because it was extraordinarily large.
Okay. Does the defense anticipate evidentiary motions in this case? Got time that maybe I can flip these. Do you anticipate evidentiary motions?
Can I just... I don't anticipate evidentiary motions from our end. Obviously, if that changes, I'll let the court and counsel know immediately, but I don't think so.
How about the Commonwealth?
There are none expected.
Voluminous.
Mr. Jackson, I'll give you until February 20th to file that motion to dismiss. And we'll hear it if there are no evidentiary. Commonwealth, I'd like you to comply with your response, if you could, by the 27th, 28th. Oh, wait, this is March, I'm sorry. No, February 20th. Yes, if you could have it by the 27th, please.
Hey, Shunka.
And then we will have a hearing on it on March 4th. If there are any evidentiary motions, they must be filed by February 11th. And I want you to talk about whether we have a voir dire of the defendant's proposed witnesses, because we'll have to do both at the same time.
Your Honor,
Right.
is it possible, I'm just looking at the calendar for the first time as the court's going through its calendar. Is it possible that I could urge the court to allow us the 24th to file the motion to dismiss? That gives us a weekend. That is incredibly meaningful for us. I don't want to hamstring the Commonwealth if they need until the 3rd to give them a weekend. Possible?
But also, I need weekends.
Right.
So it's not possible. So I'm giving you from February 11th to February 20th. I'll give you to the 21st.
Okay, 21st. Thank you, Your Honor.
Commonwealth, I'll give you to the 28th. Okay?
Thank you.
All right.
So, Judge, are we taking off 218?
We're going to take 2/8. Let's keep it on now.
Okay.
If you work out if you believe that it would be helpful after talking to do a voir dire of those witnesses, we've got the 18th free.
The 18th of
February. You were supposed to be here anyway on your motion to dismiss.
Okay, I'll discuss it with Mr. Brennan.
All right. Thank you all.
Your Honor, may I?
Yes, I'm sorry.
A few things, housekeeping matters. One, I'd like to set a date for reciprocal discovery. There has been
Yes.
a date sent. I'd like to.
All right,
ask-
so you are filing your notice of compliance today. Do you have it now to file?
I do. Can I just show
Okay.
it to the defense?
Sure.
Oh, it's an extra copy? Okay. This one, if you want it. Awesome. Thank you. May I hand this in, Your Honor?
Thank you.
Thank you, sir.
All right. So all reciprocal discovery be provided by March 6th. All right, thank you all.
One last.
Yes, I'm sorry.
Could we come sidebar for this?
Sure.
Oh, Lord. The so-called ARCCA experts. What the heck was that? Really? All right, so March 4th is the new date for the motions to dismiss. I feel like I'm gonna sneeze. How they ever? It's gonna. I feel like jury selection is gonna take a long time. It took a long time last time. Think about it this time. It's like gonna be even bigger. See, I don't know, because the defense this time, they said that they're going to cut the witness list down a lot, but he's also, so we'll have a lot less, was it snowing and were they sitting at high top tables, and a lot more snarky, slimy questioning. So I don't know, it might end up being about the same time. Debbie, hello, meant for 20 whole months. Love you all. Thank you, Brandi and mods. Much love. Thank you. Thank you. Isn't there another case with some of the same officers right now? Well, the whole Sandra Birchmore thing is federal, but that does include some of the people from this one. Will Jen be on? Oh, yeah. Oh, yeah. I think just cutting out, was it snowing? Was the apron clear? Was there a band? Will shorten the trial by about a week. Yeah. Yeah.
Mr. Brennan, anything else?
Thank you very much, Your Honor.
Mr. Jackson, anything?
No, Your Honor, thank you.
All right. Thank you all.
Court, all right, please.
We're not going to be told that
you are muted.
Canton girls basketball lost to Foxborough in overtime. What? How will we know if she's guilty or not? Yes. He had Grant. Oh, on the computer? He had Grant on his computer.
Thank you. Appreciate that. And I'm going to power it off. That's one of those 3-seconders. Basically hold it down for 3 seconds. Yep, and then hit that thing for record. All right, and you probably got. Yeah, well, I was gonna say you got about 5 minutes before she heads out. So if you want to leave your phone back here.
Goodbye.
If you want to hand it to me, I'll just go back there and put it there.
Goodbye. I know, I'm listening if there's any exciting hot mic moments.
I'm going to wait for courtroom to clear out, and then you guys are going to to go over Okay, does that work? Yeah.
I do that too. I lean in and like, but it doesn't work. All right, I guess there's not going to be any exciting hot mic moments. All right, so I have not watched any of the ASAP Rocky trial, but I heard it was good, and I heard that when the dude who was shot actually took the stand, that he like got mad at the attorney or something, and that it got kind of heated. Shunka, we're so glad to see you. If you close your eyes, it's easier to concentrate on what they're saying. Yeah, because it heightens. When you get rid of one sense, your brain can focus more on your other senses. So, ASAP trial has been awesome. That's cool. It's freaking insane. Dude was throwing tantrums on the stand. Really? I'm going to have to watch that. I'm going to have to watch that one. I honestly, I can tell you that in other trials, in places that aren't, Massachusetts, Norfolk County, that would probably be, that would probably be a thing. However, It's like a whole different universe out there. Whole different universe. Have you ever had time to watch the calling? How long was that case? The lawyer drama is hilarious. Judge, stop. Just stop. It's hilarious and frustrating. Oh my goodness, is it that bad? Dang. Interesting. A week? Where are all the babies? Lucy is right here asleep. Emmy, you can see, hold on, let me move this. You can see Emmy's asleep right here. It's got that filter thing on where it's like making everything blurry back here, but you can kind of see Emmy right here. Tinsley's over there in the door. They all guard me during the day. Chat Daddy tells them to guard me. When he leaves every day, he tells them to guard me. It's cute. Tinsley is at the door. She's right here. They look real ferocious and like they're guarding me, right? And Lucy's right there. And the cats, I don't know, they come in and out. So they're, I don't know where they are. Where is Chat Daddy? He is off working somewhere in the universe. Portrait mode, fuzzies out the back. I like it because, I don't know. It ain't none of y'all's business what's back there. I'm just joking. There ain't nothing in here. It's just office. The judge yells at everyone to stop all the time. Yesterday was day 7. Dang, really? It's that bad, huh? I feel like I need a life update from you. I've been off YouTube mostly for months, and it seems like things have changed. Everything has changed since like the end of last summer. It's been all kinds of changes. Good changes, though. So there's a dark gray, like the gray stripy cat. That's Champ. And then there's a dark gray stripy cat with white back paws. That's Scout. And then there's like he's not white. He's kind of like yellowy, orangey, but he's not really orange, but he's kind of like yellow. He's blonde. He's a blonde cat. That's Ollie. And then, of course, the Chinese box turtle is Bruce Leroy. And then the dogs. Camilla, thank you so much for the super chat. Thank you. Thank you for spending time with us this morning. You look very well indeed. Thank you very much. Thank you very much. Turtle Boy trolling on his computer has me. Yeah, I saw it. I was like, he does not have that video of Grant Smith Ellis pulled up. So funny. So I know. I went from having Lucy and the sea turtles to having, we got a whole farm up in here. We got a whole farm. So that's all right. I have not watched the Monica Cementelli? I thought I had a lot. Pets with 4 dogs. Yeah, we have 3 cats, 3 dogs, a turtle, and then a 17-year-old and a 21-year-old. Whole farm up in here. Well, the 21-year-old's not here, but you know what I mean. Oh, but he will be. He's going to come stay next week. Can you recap on what happened this morning with Karen Reed? Okay, so it wasn't... I was hoping we would get to hear more about the whole argument with the ARCCA experts, but we did not get to hear that. So the arguments this morning about the motion to recover money, that got a little spicy. Hashtag Hank was mad because he said that AJ was arguing a motion that wasn't the motion to recover. They had very different views on what they say, you know, is expected or should happen. But basically, Jackson says, I got the hiccups. I'm not a fish. I'm not a fish. Jackson says that it's an issue of equity and fairness because Karen Reed has been, of course, spending all this money for the last 3 years, and the defense has been trying to get a complete copy of all of these videos from Canton Police Department for, 3 years now. And they have gotten like scraps and fragments and clips and pieces, and everything's been all messed up, and it's just been a whole big mess, right? So they said they received the first video of the SUV going into the garage right before the trial. Remember that? And then they got the second video during the trial, the inverted video. And then they just got, in October, they just got more video. So, but when they went to the Canton PD, they said that this video system is set to delete and overwrite things after 30 days. So then where is all this other footage coming from? Well, that's kind of the question. So AJ said they knew there had to be more footage, so they wanted to go have their person, go out there and do the digital image of it or whatever, so they can get all the metadata, get the full thing, whatever. Also, the newest footage has Higgins on the phone at the Canton Police Department, and AJ said, that proves that Higgins lied about never making a phone call that night. And so they said that's, Brady violations, and that's like this whole thing of the DVR stuff. He referred to it as the way that it's being handled as a dumpster fire, and that Karen Reed is being made to pay for the fire extinguisher. Well, Brennan says that the defense is conflating the two separate issues. He says that they are, and his tone was very upset. He's very offended. I'm not a fan of him. I'm not going to pretend to be. I'm not we're past the point where I have to be I'm not a fan. I went into this thinking, oh, well, this will be better than Lally. No. He's I don't like him. So he says that he took over the case in August, and he saw a video that had not been turned over to the defense. That's a big deal. If you took over this case in August, and this is what AJ said too, this isn't about you. Okay, cool, you turned it over, that's great, but you are part of the Commonwealth. So this isn't about you, cranky hanky, this is about the Commonwealth. The Commonwealth did not turn over video that they were in possession of to the defense, and that is a discovery violation, and if it's exculpatory, then that is a Brady violation. So Brennan is saying he tried to do everything to make sure that the defense, got everything that they were entitled to, all the discovery, and he said that he reviewed the docket and there was no motion to preserve videotape. So there was a motion to preserve that Yannetti did in right at when Karen was being arraigned, but he didn't specify videotapes from Canton Police Department. To me, that's a no-brainer. But what do I know? I'm not an attorney. So he said that since Yannetti didn't specifically say that he wanted videotapes from Canton PD, that it doesn't fall into that preservation order. So so Brennan is saying that, it shouldn't count. What else? He also said that it's embarrassing that both sides have not been able to work this out, which I agree. And he said that they were not, the defense was not entitled to directly examine the DVR, but he invited it as a courtesy. So he said when he came on board, he did share that one video that had not been shared. And then he says that there's a backup hard drive on the DVR that kept things longer than 30 days. And then he says that he talked to the guy, I can't remember his name. I don't even know if he said it in this, because I said it in the podcast and I was like, I'm probably saying this wrong. He talked to the retired, I think it was a sergeant, who managed the video system, and he's the one who got the video, I guess, when all this happened. And he said that he told him that they he would routinely make copies of the surveillance videos. And he said that he has not seen what's on that copy, and he says he'll share whatever it is with the defense. But he says that nobody was misled in this case. And then Jackson, of course, responded and said that, let's not conflate courtesy with obligation, because Brennan said it was a courtesy. It's not about Brennan. Like I said, it's about the Commonwealth. So, oh, and the iCloud account. The iCloud account. Where did the iCloud account come from? Jackson said he had no idea about the iCloud account. But apparently everybody was just kind of pointing fingers at each other about, I don't know, it's a dumpster fire, like he said, with the digital evidence handling, and nobody is really taking any kind of responsibility for it. This is not how things should be run. And then ARCCA, we don't know yet. He called them so-called ARCCA experts, which is stupid, but okay, we'll go with it. The so-called ARCCA experts, he says, but they did that all in a sidebar, so we don't get to hear any of that. Other than that, it was just scheduling and discovery being turned over. The motion to dismiss is going to be coming in, and the hearing on that will be March 4th. And that's pretty much the recap of what we had happen today. Hello, hello. The fact that they just got another video is insane to me, especially because he got a video that he turned, whatever it was, like that he turned over in August. They were already in possession of. This isn't like new investigation, new, hey, we went and found this. This is stuff that they had, and that's a big problem. Like that's a big problem. Big problem. Police department shouldn't delete case file. There should be, if there's a murder trial, and like if you're saying that this car is the murder weapon, why would you delete videos of the murder weapon? No, I don't get it. Zach, I almost saved enough money for a monthly membership. So close. So close, Zach. So close. He confessed Brady violation. That's, I mean, especially because the video with Higgins too, it's because if at bare minimum, it's a discovery violation. But if it's exculpatory evidence, then that's a whole different ballgame. And then we're looking at, sanctions and what you're going to do about it. I mean, there's a whole big, if it was the defense who had done it, it would be. It has nothing to do with my fear of commitment. I had that issue as well. They shouldn't have to submit a motion, in my opinion. It's the Commonwealth's responsibility to preserve evidence, right? Right. To me, that would be something that is a big deal. Also, why is CBD even putting evidence in whose iCloud account? Whose? Why is there an iCloud account? What? What? Crazy. I think the video is backing into the Sally Port. We saw them drive into the Sally Port. So are they backing in now? Or is this like the inverted thing, but now they're doing it in rewind instead of, because it wouldn't surprise me at this point. Just like, hey, let's just do all these things and then see what they notice. Breezy, thank you for getting memberships. Get to 5 memberships. Why did we not hear about the iCloud account previously? And why is there so many, why are there so many problems with the chain of command when it comes to these videos? Why is this such a big problem? I don't understand. All I can say is I hope that this changes policies for Canton Police Department and whatever other police departments happen to watch this, because bruh, could you imagine being like the defendant or the person whose family member, was like hurt or murdered or whatever, and this is how they run things? This is something that should bother everybody. Everybody. It doesn't matter if you think that she's guilty. It doesn't matter if you think that she's innocent. It doesn't matter if you don't know if she's innocent, but don't know if she's guilty, so which would be a not guilty. But you know what I mean? I think that that's the biggest thing. Is it doesn't matter what you think happened. We should all be worried about the way that things are being handled here. And that's the big issue. Like, if you are, and Runkle said this the other day, I retweeted his tweet. This is something y'all have heard me say this a million times. If you think that she's, guilty, you should be even madder than the people who think she's innocent for the way that things were handled. Because if you think she's guilty, then it's the way that the police handled everything could have a huge role in her potentially going free. So if you think she's guilty, you should be, instead of defending solo cups and, the shit show that is Canton PD, you should be mad. You should be mad. Yes, she did back into his car, leaving the garage. Red solo cups. John's family seems to just hate Karen Reed. And look, I have said this 100 times. I will never speak badly of them because I cannot imagine the pain that they are experiencing. And when people, and I've seen before, and people who have been exonerated and like it was proven that they were not the guilty parties, and the family of the victim will still hold on to that. So I think that it is an emotionally, very touchy situation. And you never know what you would do or what you would think if you were in their situation. So I don't fault them for the way that they feel about or toward anyone, because I can't imagine how hard things must be. Because they want justice for John O'Keefe more than anybody else. But people have different perceptions of what that looks like. To me, justice for John O'Keefe is not just a conviction. Justice for John O'Keefe is, having things go by the book and having justice should have started with the way that the investigation was handled, and it didn't. And that's the part that really sucks. We know based on Brian Camp and Penny McGee, proper handling is possible. Why not in this case? That's the thing I don't understand, because there are cases. This is not just like, like, oh, they mess up every case they're on. It's not that. They don't mess up every single case they're on. But for some reason, the same protocols that they follow in other cases, they're just like, don't worry about it. Don't worry about it. Grab me a Stop and Shop bag and a solo cup. I'm good. I'm good. Yeah, they want to feel like it's been solved. I think that, I've having talked to so many family members of, victims of either extreme violence or, or even like family members of people who've been murdered. One of the things that has always been kind of, something that I found interesting was that they do have that not all of them, but this has been something that I've heard from a lot, where having somebody specific to be angry at, to like place the blame on, has been important for them. How did she word it? She said, because there was like 3 or 4 months, I'm not going to say who it was, but there was like 3 or 4 months where they didn't know who was responsible for her son's death. And then when the investigation got to the point where they like had a main suspect, she said, I can't remember exactly how she worded it, but she said it was almost like a relief, because everything that she felt was just grief. So now she had somewhere to like focus her anger on, and it was less emotionally damaging for her to focus anger on somebody specific than to have to live in the grief. And it turned out that main suspect that they had was not the person who did it. They didn't solve it until like 3 years later, and it was somebody totally different. But she spent 1.5 years really angry at this person, and even when they were able to prove that it was somebody else, she said it was hard for her to turn over, like to redirect that anger towards somebody else, which I found really, really interesting. Really interesting. And I mean, it makes sense from a psychological level, but I thought that was really interesting. There was a great guest on the Young Jurors last night who was explaining why the Sidebar video was tampered with and how it was likely done. She reminded me, Abby, right? Is it Abby? I think is her name. Yeah, I had talked to her a while back about having her on the podcast, and then, and she said yes, and then we haven't had a chance to do it yet. So I would still like to have her on, or maybe I'll just see if, I'll talk to Mike and see if I can clip some of the explanation stuff from that video. That way I can kind of promote both of them. Not to have the full video uncut is a little suspicious. Yeah. Don't be suspicious. Don't be suspicious. Yeah, anger is easier to live with than grief. Yes. So I don't fault the, victims or the family members of any victims for how they feel, what they do to, get through what they're feeling. I don't have any, I don't have anything negative to say about any of them, because I can't imagine being in that position, and you don't know how you would feel or what you would react or what you would need in that position. So oh yeah, there's been a lot of online fights between people, and I honestly have stayed completely out of it. I am in my happy, peaceful little bubble, and I don't want to be a part of anybody's fights, and I don't want to have to take sides. So I just stay out of all of it. Even when they come after me, a friend texted me last night and was like, hey, did you see, they're saying stuff about you? I was like, nope, sure didn't. Don't look at it. Ain't nobody got time for that. Right? I sure don't. I'm living in my peaceful, happy little bubble. All right, guys. Well, I guess that's it. I wish that we could have gotten to hear some of the arguments on the Crash Daddies. I wish they wouldn't have done that in a sidebar, but hopefully we'll hear from them soon. It's amazing how far, no boundaries, none. No. Contacting my family, doxing my friends. Yeah, they're crazy. And then they're like outraged if something happens like that to one of them. It's crazy to me. So yeah, I don't get involved. I let them all just do their own thing and try to destroy each other while I'm just over here living my best life. Ain't nobody got time for that. All right, so I'll have this and whatever else happens between now and next week, I'll have this in next week's episode. And also I am going to try to have the final Letitia episode. So what I did, I talked about this a little bit earlier, but in chat, but I'll say it for those of you who don't read chat. The first 6 episodes that I did of the podcast were just the audio from my Letitia recap videos that were put onto, like, put as the podcast. Those were my first 6 episodes. It was just, so it's really just like a video of me talking like this, doing the recaps, and that audio is made. So what I did is, and I have a reason for it, I'll tell y'all at a later date, but I went through and I took all of the recaps that I did, and then I went back and watched some of the, like, listened to the calls again and watched some of the interviews again and stuff. So I took all of that and then I wrote it all out the way that I do with the other podcast episodes. So I wrote it out more as like a story instead of like just like, then it was this witness, then it was this witness, to make it more cohesive and to tell the full story. So the first 6 episodes of the podcast were that. So they have all been reloaded. The date's not changed on them, so nobody got notifications that they had been redone. It's just the audio is just replaced. If you still wanted the original audio, it's still available on the YouTube videos, but all of those have been replaced. So now there's a 7th video. So that one will be, or podcast, not video. There's a 7th podcast episode that I will be adding. The first one only had 6, and the 7th one will be the full defense and then what's happened since then and all that. So, defense and verdict and all that. So if you are interested, I spent a lot of time on them, and I'm very proud of how they turned out. And you do hear me, because y'all know I struggled with that case, because I struggle on the cases with the kids. So you do hear me a couple times. Like, you can hear my voice crack when I start to cry when I talk about Gannon. But other than that, they turned out really good. So if you want to listen to those, the 7th and final episode of that should be out next week, along with an episode of Conspiracy in Canton. So both should be out next week. Sound good? All right. Well, I'm going to call it a day because I've got work to do. I want to take these DOGs OUT and then come back in here and get to work on all the stuff I got to do. And put on a tank top because it is hot. Y'all, it's like 90 degrees. Hold on, let me see what. I mean, not in here, but. Can't remember my passcode. $82. I was close. It's hot. Don't be telling me that it's snowing here. Oh, sorry. Yeah, it's hot here. But that's good. All right, so listen to Letitia. Listen to those. Listen to the latest Conspiracy in Canton episode. It dropped yesterday. And we will get together again very soon. I love y'all. And I miss you. And I'm glad to see you. Be kind to each other. And I'll see y'all soon.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?